today. So my conclusion is the experiment's not the only path of science. And one of the reasons I bring this up is so many social psychologists, and I do have a cross appointment in the psych department. Every time I hear them, my lab, and it's starting to get to the point that unless you're running experiments, it's not scientific. And I think that a lot more could be learned from doing this. Now, again, the talks today, Tom was talking about it, so many of the other talks actually have been interviewing people, and I think, Tom, you were talking about it. So that's my apology. So it's not speaking to you in this regard, but basically saying this is a problem, and it is a problem that some of the law professors brought up this morning in saying when you try to apply what we do as social psychologists, especially when you have been doing the kind of basic research that a lot of people have been doing, judges are real critics. They are skeptical. What do those artificial studies do? And of course, when testimony comes out and lawyers cross-examine them, you know, they bring up all of these kinds of flaws, and the judges are very skeptical. They are far more receptive to the kind of in-depth sort of study, because I've testified before, and I try to mix the laboratory studies with the empirical studies that I've gathered to try to do that in my testimony, the affidavits and so forth that I've written. So those are the kind of comments that I wanted to make. So I'm not opposed to experiments, but I think that what we need to do, and other people have talked about it today, is seek evidence of convergent and divergent validity with different methods and data sources. But in doing this, think about ecological validity, because so many of the studies are there, and there's no reason why we can't do that with our studies. So I'm sort of tossing out a gauntlet, but well, like I said, I've kind of got the wrong audience to talk to, because I like to be tendentious, but I sort of feel that I don't have the right audience for that. There's just one other thing that I want to do, since I have a couple of minutes left, because one of the things that I also want, another point that I would like to make is, a lot of that is taking the applied research, and basic research, and saying, does it apply in the setting? But alternatively, sometimes the law can suggest some really interesting hypotheses to us. And one of these that I want to talk about, most of you are probably familiar with the punitive damages cases of BMW versus Gore and State Farm versus Campbell. And in State Farm, they made the statement that the Supreme Court, the most indicium of the reasonableness of punitive damages is the degree of reprehensibility of the defendant's conduct. The second is the relationship between compensatory and punitive damages, the relationship between punitive awards to criminal penalties for the same conduct, and it says a state cannot punish a defendant for conduct that may have been lawful where it occurred. And that was the problem in BMW versus Gore. The case was involved all throughout the United States. BMW versus Gore, if you remember, is the doctor that bought the BMW and had $1,400 worth of damages, or $1,600, and most of you will remember that. If you haven't had it in law school, you remember it from other reasons, and it was a whopping big thing. And one of the things the court said was, you can't punish for behavior outside of Alabama, because this is not applicable. The states may have different laws, so there was a real concern there. Similarly, in State Farm, they made the same point, because the people in State Farm, Mr. Campbell in State Farm versus Campbell, the instructions were, but State Farm did this in a whole bunch of other states, the same thing, not paying up to him and not, trying to settle the case, and it was. And that's what ultimately ended up in their punitive damages. But State Farm ends up, first of all, saying you can't punish in another jurisdiction. And the second thing is, we've instructed the courts to determine reprehensibility of the defendant by considering whether the harm caused by it was physical as opposed to economic, and it was economic in both of those cases. The tortious conduct evinced an indifference to a reckless disregard of the health or safety of others, the target of the conduct that had financial vulnerability, the conduct involved repeated actions or was an isolated incident, the harm was the result of intentional malice, trickery, deceit, or mere accident. Now we come to Philip Morris. Philip Morris is a case that was just decided this last February by the Supreme Court. And Philip Morris involved Mr. Williams, who was a Marlboro cigarette smoker for most of his life. He died, and actually at trial, they brought out the fact that Philip Morris knew what it was doing for years. All of the stuff maybe you've read about, although you almost have to read those cases to see how egregious their behavior was. They actually engaged in fraud. Interestingly enough, they never contested the fraud from the beginning, but they were trying to, one of their arguments was, this is not fair. And the lawyers in that case argued, no, what we're talking about here is Mr. Williams was wronged, but their behavior influenced all of the other people of the state of Oregon and nobody else. So they were very careful to fall within the constraints of what State Farm had said. So it's not elsewhere, this is only Oregon, and they presented the evidence on this. And what the court says is harm to others is not permitted in awarding punitive damages. Well, in fact, if you look at the instructions that they were given and what the Oregon Supreme Court said, it was limited. And so it's a complicated kind of a problem. But here's the interesting psychological problem for us, where I think we can get into some interesting discussion. What the court says is evidence of actual harm to non-parties can help to show that the conduct that harmed the plaintiff also posed a substantial risk of harm to the general public, and so was particularly reprehensible, although counsel may argue that the conduct resulting in no harm to others posed greater risk to the public. So what the court actually said there, it's a very confusing opinion that the Supreme Court has said, is you can't consider third parties as getting some of the punitive damages, although in Oregon, the whole state of Oregon, we get 60% of whatever punitive damage award was there. But they're saying you can't give an award on the basis of harm to other people, but on the other hand, you can consider the harm to other people that plays in your sense of reprehensibility. Now, only a law professor or a Supreme Court justice could come up with that. And so there's some really interesting practical questions, and here are my two, and I'll sit down early. Here's my question for psychological issues. How are psychological judgments of reprehensibility different from retributiveness? John Darley, I was thinking of you on this because we've both written in this area, and I have not given it a lot of thought, but I actually have some ideas of doing some research. And then the question that actually comes up as well, which evokes a lot of these emotional issues and intuitive judgments, is how will jurors respond to the various jury instructions that will attempt to cabin the jury's response in the wake of Philip Morris? And we don't really have a clue at this point. So this is an interesting question, but I think underlying it are a lot of interesting psychological questions. One's for social psychologists. I'm going to be doing that. If anybody's got any ideas, I'd love to do it. But I guess my main point about all this is that sometimes the law gives you some really interesting hypotheses that we haven't thought of before. And I think that's the end. Oh, I did want to bring up an advertisement for you, if I may.
Did you just send that to the publishers, and it's coming out?
Yes, it'll come out in October.
I'm getting a copy. Maybe
well, of course. Look at all the sales. We need the royalties. Okay, I think that's got it, John.